Welcome to this AIM Quick Guide addressing access to public buildings and public areas. Across the country, Indiana included, there has been an uptick in the individuals visiting public buildings and recording or attempting to record their visits. When asked, these individuals generally respond that they are conducting a First Amendment audit. While they are testing local knowledge of the First Amendment, it is important to note that the term First Amendment audit is not an official term, and these individuals are not conducting an audit sanctioned by a government body or bodies. While this AIM Quick Guide attempts to provide you with a starting point for gathering additional information and informing those in your office who interact with the public, we suggest you contact your municipal attorney for more comprehensive instructions. Your attorney can help you work through the specific scenarios you might face and how to address them when or if they arise. Your counsel can also help you identify which public areas are not accessible to the public and how to identify those areas. Even in a public forum, government is permitted to establish reasonable time, place, and manner restrictions. While time, place, and manner restrictions are allowed, 1. They must be content neutral. 2. They must be narrowly tailored to serve a significant interest. And 3. Ample alternative channels of communication must exist. Depending on how the public space is utilized, there are many things to consider when determining whether space is off limits to the public all or some of the time. There is a responsibility to protect information in your buildings. For example, if someone were to film a utility clerk's desk and see a private third-party customer's check with an address or bank account information, there would be concerns about the breach that could occur from sharing that information. An agency must regulate against material interference of duties, which includes protecting confidential, discretionary material. Once you have determined how to proceed, clearly and visibly mark areas that are open to the public and those that are not. For more information on access to public buildings, read IC 5-14-3-7, People v. Barnes, or Minnesota v. Mansky. They are cited in this quick guide. Once you've talked with your attorney and identified both open and closed public areas, it is recommended that you sit down with your local government teams right away in anticipation of any such challenges to your First Amendment knowledge and interpretations. Place a high priority on those individuals that would be first points of contact in public places and buildings, and your local law enforcement. It is imperative your employees feel prepared and collected, because ultimately, many of these contacts are being posted on media sites such as YouTube. As public servants, it is important to approach these matters with a desire to grant access as appropriate and be responsive to members of the community that have requests. However, it is equally important, as suggested earlier, to give forethought to what may or may not be appropriate before an approach or conflict arises. Create or modify your plan for how to respond to these requests, particularly those that occur on camera, which can be intimidating to public employees, but may not be unlawful or prohibited. Post clear rules such as, no person shall enter municipal property for any purpose other than to conduct legitimate business with offices or tenants located at municipal property, or to enjoy publicly accessible amenities in public areas, or to lawfully assemble for social or public interaction in public areas specifically designed for such assembly. Limited access area means an area designated on municipal property as not generally open to the public, open on limited or by invitation basis, or is an area occupied by the public in close proximity to private third parties conducting business with municipal employees. Limited access is designated by barriers, building design features, signage ropes, reception desks, or other visible indications the municipality retains the right to verbally instruct third parties that an area is a limited access area. Signage could indicate, for privacy of municipal customers, stand behind this line until business at the counter is completed. Consider a conduct policy that makes clear: no person shall engage in activity that disrupts or interferes with the normal operation or administration of business at municipal property, lawfully in use by employees and authorized visitors at property or municipally permitted activities. No person shall stalk, harass, threaten, intimidate, or otherwise compromise the well-being and safety of employees or private third parties lawfully using municipal property. Recording of private, personal, confidential, or privileged information is prohibited. Cities and towns should have a way for individuals to request documents and an understanding of how to respond to public inquiries. The first points of contact in public buildings need to be aware of these plans and answer questions if asked for access to the building or access to documents. Some cities and towns have considered individuals pursuing these filmed interactions trespassers. If your community is considering this approach, work with your teams in advance to determine how to grant maximum allowable access. If there are clear safety concerns and you move forward with a trespass, there are a few things to consider. The individual must still be granted access to any public meeting for open door law purposes. You may have law enforcement or safety measures in place to address safety concerns. Consider setting appointment times for individuals to be given access to speak with employees if that is the request. If you are aware in advance that an individual or group will attempt access you deem will be trespassing, the individual must be on notice of the trespass. The individual or group should be verbally informed on a prior visit, sent a certified letter to an individual's or group's address, or asked for signature to prove notice. For more information on trespassing relative to public buildings, both McBride versus State of Indiana and United States versus Powell are cited in this quick guide. The accessibility of public buildings is not easy to define, especially in the heat of the moment when well-meaning government employees feel ambushed or nervous due to the use of a camera or phone and commonly vague responses from those filming who do not identify themselves. Your community's response will be best with a reasonable amount of advanced preparation and discussion with your municipal attorney. However, the best piece of advice, and one that does not need legal review, involves maintaining a calm demeanor and approaching the situation with a desire to help the citizen accomplish what they are trying to accomplish without violating any laws, policies, or, of course, the safety of the public or the municipal employees involved. Regarding the ability of the public to obtain the names and/or contact information of municipal employees, consult your counsel for these allowances and incorporate this scenario into your training and preparations. For questions regarding this AIM Quick Guide, email AIM General Counsel Becca McQuaig. This AIM Quick Guide is sponsored by Commonwealth Engineers. Commonwealth Engineers helps communities with their most challenging water resource needs. We take a holistic approach, including technical, financing, regulatory, and operations considerations. To our existing client communities, thank you for your trust. To those we have not yet had the pleasure to work with, please contact us to discuss how we can be of assistance. Visit us at commonwealthengineers.com.